morning, children. And this is, yes, Srikanth signing in for contracts. Slowly, we are moving to the capacity of the parties, capacity or competence or qualification of the parties to enter into a valid contract. You know, in a contract, two persons will be there. These two persons, either the offerer or acceptor, they should possess certain capacity or competence or qualification. Indian Contract Act clearly and specifically mentions that certain persons are not entitled to enter into a contract. That means it is specifically mentioning certain qualifications. So, any person can enter into an agreement, but only if that agreement has to become an enforceable contract. Definitely, the person should possess certain capacity or competence or qualification. So, in this class, we are going to see what is the capacity or competency of the parties to enter into a contract. So, the meaning of the term capacity means competence or qualification of the parties to enter into a valid contract. If you kindly analyze section 10 of the Indian Contract Act, if you remember section 10 of the Indian Contract Act, it prescribes certain conditions. What are those conditions? Two parties, consensus ad idem, capacity to contract, free consent, lawful consideration, legal relationship, lawful object, terms must be certain, possibility of performance. So, here one is that is capacity to contract. Section 11 speaks about this. So, a contract to be valid, what happens? The parties must be competent to contract. So, what is the meaning of the term contract? All agreements or contracts, if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. So, contract should be made by free consent of the parties, and this party should be competent enough to enter into the contract for a lawful consideration, lawful object, and this contract should not be expressly declared to be void. This is what the agreement specifically mentions. So, the contract should be made with the free consent of the parties, and they should be competent enough to enter into the contract for a lawful consideration. No unlawful consideration, unlawful object, no unlawful objects, and especially this contract should not be forbidden by the law. So, the term capacity or competency means the qualification of a person to enter into a contract. Any person cannot enter into a contract. He has to possess certain qualifications mentioned under section 10 and 11. Let us see what it is. Section 11 of the Indian Contract Act speaks about every person is competent to contract, but provided he should attain the age of majority according to the law to which he is subject, and he should possess sound mind, and he should not disqualified from contracting by any law to which he is subject. So section 11 tells every person can enter into a contract. Only it says the person, he should be a major and he should possess a sound mind, and he should not be disqualified from contracting by any law. This is what section 11 speaks about. Three things it is telling. Any person can enter into a contract, there is no restriction. The only thing is he should be a major, he should possess sound mind, and he should not be disqualified by the law to enter into the contract. So section 11 specifically speaks. So disqualification by infancy, disqualification by insanity, and special disqualification. So, according to section 11 of the Indian Contract Act 1872, any person is competent to enter into a contract provided he or she is a major, he or she is of sound mind, he or she must have not been disqualified to contract by any law. For example, assume that contract is between A and B. Both persons should be major. Both A and B should possess sound mind. Sound mind means they should not have any unsound mind. They should not be idiotic or lunatics, and they must not have been disqualified to contract by law. Assume that he is a major, assume that he is having sound mind, but still courts will say you cannot enter into the contract. Even though he is a major, even though he is having a sound mind, till courts will say you cannot enter into the contract, means you cannot enter into the contract. Why? He has been disqualified by the law. So even though he is a major, even though he is having sound mind, still courts will say you cannot enter into the contract. Then at that time this person cannot enter into the. So minors, persons of unsound mind, and persons disqualified by law are not competent to enter into the contract. So, in this lesson, we are going to see what is the meaning of the term minor, and who are the persons of unsound mind, and who are the persons disqualified by law. So, let us analyze the definition of the term minor. So, according to section 3 of the Indian Majority Act 1875, a minor is a person who has not completed the age of 18 years. Who is a minor? A minor is a person who has not completed the age of 18 years. If you complete 18 years, then what happens? You become a major. Then this minority extends to 21 years when, if a guardian of a minor's person or property is appointed under the Guardians and Wards Act 1890. Normally we are having so many acts. So Indian Majority Act, Guardian and Wards Act 1890. So, Section 3 of the Indian Majority Act tells a minor is a person who has not completed the age of 18 years. Then Guardians and Wards Act tells a minor is a person who has not completed 21 years of age if his person or property has been appointed. So in fact, so different acts speaks about different terms of the minority, and we have to interpret according to the law with which you are entering into the contract. So a minor is a person who has not completed the age of 18 years. Now section 10, if you go to section 10, it speaks about the competency of the parties. Section 10 of the Contract Act lays down that contracting party should be competent to contract, And section 11 expressly provides that a person who has not attained the age of majority according to the law to which he is subject is incompetent to enter into a contract. So normally what happens is a contract entered into a minor is void ab initio. So there are certain contractual capacity of the minor. If we enter into the contract knowingly or unknowingly with a minor, it is void ab initio, and a minor can be a promisee or beneficiary but not a promisor. No ratification, no restitution, no estoppel, no specific performance, no vicarious liability. So these are the consequences which arise out of the minor's agreement or contract. What are they? If you enter into a contract, first one is its void ab initio, and a minor can be a promisee or beneficiary but not promisor. No ratification, no restitution, no estoppel, no specific performance, no vicarious liability. Let us analyze one by one. So, first one is void ab initio. It means invalid at the very beginning. Earlier, a contract entered into with minor is voidable, but the Privy Council made it essential that all the contracting parties should be competent to contract, and held that a contract entered into with a minor is void ab initio. So a contract entered into with a minor is void ab initio, means చెల్లదు. కాంట్రాక్ట్ మైనర్తో మీరు ఎంటర్ అయినారంటే ఫస్ట్ నుంచి అది చెల్లదు. వాయిడ్ అబ్ ఇనిషియో మీన్స్ ఫ్రమ్ ద బిగినింగ్. We have seen one case here, Mohiri Bibi versus Dharmadas goes. So here what happens is one minor was there, he wants some money. So what happened is he mortgaged his house. Mortgaged means he has went to a money lender and told that money lender that please give me some money. I will give my house as a surety, mortgaged to the money lender, and received an advance of rupees 8,000. This minor has received advance of rupees 8,000. Now subsequently what happens is this minor wants to avoid the contract and he did not return the advance. Again, subsequently, this minor filed a suit in the court to set aside the mortgage deed that has been entered into by the minor with the money lender. Then the court held that the contract with a minor is not enforceable on the ground that an agreement with a minor is void ab initio. This rule is popularly known as rule in Mohiri Bibi versus Dharmadas Ghosh. So here this person knowingly or unknowingly entered into a contract with a minor. Remember, if you enter into a contract with the minor, he can take all the benefits, but he is not liable for the damages or whatever it may be. So contracts entered into with a minor is invalid at the very beginning. So contract entered into with a minor is void ab initio. So if you want to enter into a contract, you should be careful enough to see that the person is not a minor. Suppose if he is a minor, then your contract suffers from the disqualification mentioned under the Indian Contract Act. So contracts entered into with a minor is first one is void ab initio, right? Second one, a minor can be a promisee or beneficiary but not promisor. A minor can be a promisee or beneficiary but not a promisor. That means he can take all the benefits and enjoy all the benefits. He can enjoy the benefits and privileges under the contract, but he cannot be held liable for the what is called liabilities under the contract. For example, A is there. A wants to gift some property to B and B is a minor. Now A can give the property to minor and minor can take the property. Remember, but minor cannot gift his property to any other person. That means he can enjoy the benefits, but he cannot transfer his liabilities. So a minor donee, he minor donee in a gift, two parties will be there, donor and donee. Donor means who is giving the property and donee means who is taking the property. So minor can take the property but minor cannot give the property. So he can be only a promisee or beneficiary but not promisor. மைனர் வந்து எல்லா பெனிஃபிட்ஸும் வாங்கிக்கலாம் பட் లయబిలిటీస్కి அவன் పొరుపు கிடையாது. మైనర్ వచ్చి అన్ని బెనిఫిట్స్ తీసుకోవచ్చు కానీ వాడిని మీరు లయబిలిటీస్కి మీరు ఇన్కర్ చేయలేరు. దిస్ ఈస్ వాట్ ది సెకండ్ స్పీక్స్ అబౌట్ ప్రామిసీ ఆర్ బెనిఫిషియరీ బట్ నాట్ ప్రామిసార్. Next one is no ratification. Ratification means subsequent acceptance or approval or sanction. For example, A is there, B is there. Assume that B is a minor. A enters into contract with the B, that is minor. It is void ab initio. But on attaining majority, B says, I will accept this agreement. The court says no. Why? A minor's agreement is void and being a nullity, it has no existence in the eye of the law and therefore it cannot be ratified and it cannot support a fresh promise by the minor after attainment of the majority. At the time of entering into a contract, if the person is a minor, the benefits of minority would continue even after attaining his majority. He need not ratify the liability after attaining his majority. So, in contract with the minor, minor cannot ratify. That means he cannot subsequently give his acceptance, approval or sanction. So capacity to contract, what are those capacities? He should be a major, he should possess sound mind, and he or she must not have been disqualified to contract by law in force. Now we are analyzing first aspect, minor. Entering into a contract with minor is void ab initio. Minor can be a promisee or beneficiary but not promisor. No ratification, no restitution, no estoppel, no specific performance and no vicarious liability. Remaining we will see in the next class. Good day children. This is Srikanth signing off today.